what if the exact system that banks use to basically trap you in debt could somehow be legally weaponized?
Right, like weaponized to actually seize their assets instead.
Exactly. I mean, today we are looking at this massive stack of pretty controversial procedural outlines.
And these documents claim that you can literally foreclose on your own bank.
Which is wild, and doing it all without ever, stepping foot inside a courtroom. Welcome to the deep dive, by the way.
Yeah, we are unpacking a highly structured, and I mean incredibly dense 5-stage commercial procedure today.
Right, and in these documents, it is known as administrative due process.
Administrative due process.
Yeah, and the mission for this deep dive is, to explore how individuals try to use the Uniform Commercial Code.
UCC.
Exactly, the UCC. And the rules of administrative procedure to essentially, turn the immense weight of a corporate entity against itself.
The documents you provided offer this really fascinating intellectual journey because they completely reimagine the power dynamics of modern debt.
They really do. It's like flipping the board upside down.
Yeah, we are looking at articles, legal frameworks, and these step-by-step procedural blueprints. They read almost like a hacker's manual, honestly.
A hacker's manual for the financial system. I love that description.
Right, because they identify vulnerabilities in the way these mega banks process information, and then they attempt to exploit those exact vulnerabilities using the bank's own rulebook.
But hey, before we get into the actual mechanics of this hack, I need to be absolutely crystal clear with you, the listener, about what we are doing today.
Yeah, full disclaimer time.
For real. The concepts we are discussing in this deep dive contain legal and procedural theories that, a lot of people consider legally unorthodox.
Very unorthodox.
And some find them highly politically charged. So let me state for the record right now, we are not taking sides.
Not at all.
We are not endorsing these viewpoints. We are not validating their real-world success rate. And we are absolutely, unequivocally, not offering any legal advice.
Our role here is purely analytical. We are just acting as impartial guides to the source material you've provided.
We're just the messengers.
Exactly. The goal is to just convey the exact ideas, the internal logic, and the mechanical steps contained within these original documents. We are exploring the architecture of the theory.
The architecture, right. And the ultimate goal of that architecture, like the core thesis of these documents, is to move an individual from playing defense.
Right. Moving away from being the debtor.
Exactly. From a defensive debtor to playing offense as an enforcing creditor.
And the kicker is doing it all without ever asking a judge for permission.
Okay, let's unpack this. Because the sources present this like an engineering schematic.
They really do. It's very mechanical.
So to understand how the machine works, we first need to understand the materials it's built from.
Right.
We have to start with the foundational worldview.
Yeah, to really comprehend the procedure, you first have to adopt the specific lens through which these authors view the world.
And it is a very specific lens.
It is. The sources strictly divide reality into two distinct, non-overlapping categories.
Two buckets, basically.
Exactly. You have the living man or being, and then you have the corporate human entity.
So there is this fundamental dichotomy at play. It's not just, me versus the bank. It is flesh and blood versus legal fiction.
Right. According to the texts, the living man, the breathing physical being, acts in what they call a private capacity.
Private capacity, okay.
Yeah, this is the realm of the physical, the tangible, the actual. It is grounded in natural law.
Okay, so that's us, the breathing humans.
Right. But the bank, the mortgage lender, the credit card company, and even, the formalized version of the citizen.
Wait, the formalized version of the citizen? Like my legal name?
Exactly. All of that, on the other hand, is viewed merely as a procedural fiction.
A fiction.
Yeah. They are entities created by paper, existing only in the public commercial realm. A corporation doesn't breathe.
It doesn't have a soul.
Right. It only has power because a framework of laws agrees that it does.
And the sources have a very specific way of visually and legally distinguishing the living man from the corporate fiction.
They do. It all boils down to the signature.
His signature. This part blew my mind.
Yeah, they specify that to prove you are acting as a living entity in a private capacity, you must use a wet ink signature.
A wet ink signature. And it specifically has to be in blue ink.
Blue ink. Always blue ink.
They even note it should typically be placed on the right side of the page, which is just, it feels so incredibly specific. Why is that? Why is blue ink the cornerstone of proving your humanity?
Well, the internal logic is deeply rooted in physical reality versus mechanical reproduction. Think about the history of document duplication.
Like old photocopiers.
Exactly. For decades, black ink could be easily photocopied or carbon copied. A photocopy of a black signature looks indistinguishable from the original to the naked eye.
Yeah, it's just black lines on white paper.
Right, it becomes part of the mass-produced automated machine. But wet, blue ink leaves a physical impression on the paper.
Like an indentation.
Yes, an indentation you can literally feel with your thumb. And it is immediately visually distinct from a black and white commercial copy.
So it's an undeniable artifact of human action.
Precisely. It signifies that a real, living hand pressed a pen to this specific piece of paper at a specific moment in time.
Wow.
It grounds the document in physical reality, mathematically separating the living man from the abstract, automated paperwork of the corporate fiction. The blue ink is a physical tether to the private capacity.
Which brings us directly to the absolute bedrock rule of this entire framework. If you only remember one concept from this deep dive, for you listening at home, it has to be this.
Substance over form.
Substance over form. Everything else cascades from that single premise, right?
It's the engine driving the entire procedure. Substance is the property of the living man.
And how do the sources define substance?
They define substance as actual material reality. It is the physical car you drive, the actual bricks of the house you live in, the sweat equity you put into maintaining a property.
Tangible things.
Yes. Or, crucially, it is the original physical promissory note that contains that original wet ink signature.
Ah, okay. And conversely, form belongs to the bank.
Yes. Form is the procedural fiction.
The paperwork that represents a thing but isn't the thing itself. Like a menu isn't the food.
Great way to put it. The primary example the sources use for the bank's form is a simple computer printout or a photocopy of a contract.
And the absolute unbreakable rule of this administrative framework is that substance legally defeats form every single time.
Right. If you can force a confrontation between substance and form, the philosophy dictates that substance must win.
Because form only derives its power from the substance it mimics.
Exactly.
Let me try to visualize this because legal philosophy can get really slippery.
Yeah, analogies help here.
Okay, so imagine two people are arguing over who owns a physical house. The bank's lawyer comes to the table holding a photograph of the house.
Okay, and that photograph is the form.
Right. It represents the house. It perfectly depicts the house. It even has the address written on the back. But I come to the table holding the actual physical bricks of the house.
And the keys.
Yes, the actual heavy metal keys that open the front door. I am holding the substance.
So the bank is holding a representation. You are holding the reality.
And the argument here is that the physical reality defeats the representation. The keys beat the photograph.
And you can see how radically this philosophy shifts the power dynamic from the very first interaction.
Completely flips it.
Because the modern financial system relies almost entirely on form. Banks rely on automated databases, spitting out millions of lines of generic statements and photocopied notices.
They just deal in data.
Right. By demanding the original wet ink document, by demanding the substance, the living man forces the immense corporation out of their comfortable abstract world of infinite digital paperwork.
You drag them into the real world.
You are dragging them down into the physical realm.
You're calling their bluff. You're basically saying, don't show me the digital scan of the contract you claim I signed. Send a human being down into your physical vaults. Find the actual original piece of paper that my physical hand touched with the blue pen and bring it to me.
And the implication in these sources is that due to the nature of modern banking, the bank very often simply cannot do that.
Really? They just lose the paperwork?
Well, the sources lean heavily on the realities of securitization. In the modern mortgage industry, for instance, loans are bundled, sold, sliced into tranches, and digitized.
Oh, right, like during the 2008 crash.
Exactly. The physical paper notes are often lost, destroyed, or buried in warehouses halfway across the country. All the bank has left on hand is the form.
A scan on a server somewhere.
Exactly.
Okay, so we've established the philosophical ground. Who is the real living entity and what constitutes physical substance versus corporate form? But philosophy doesn't stop a foreclosure.
No, it doesn't.
You need a mechanism. You need a way to communicate that forces this giant corporate fiction to actually play by your rules.
And the documents outline a very specific communication framework designed exactly for that purpose. They refer to it as the I-Thou-He triad.
The I-Thou-He triad. Let's break those three down because it sounds a bit, archaic. Like Shakespeare.
It does, but it is a structural approach to legal correspondence.
Yeah.
I represents the living man who is initiating the administrative process, the sovereign individual taking action.
Okay, the I is me. Got it.
Thou represents the corporate entity, so the
Hmm.
bank, the lender, the agency that is receiving your demands.
And the he is the one that seems kind of out of place to me. Who is the third party in a dispute between me and my bank?
He is arguably the most vital piece of the entire strategy.
Really?
Yes, he represents the independent third-party witness. In this framework, he is the record itself and often the physical person of a notary public.
A notary. Okay.
Because you aren't just sending a letter to the bank and hoping they read it, you are officially communicating with the bank for the record.
Yeah.
You are building an unassailable paper trail that a third party can independently verify.
Okay, so I am writing to thou, but he is watching and taking notes.
That's a great way to think of it.
And the entire legal mechanism of building that record hinges on a concept that sounds almost too simple to be true. Acquiescence.
Silence is consent.
Silence is consent. I mean, in our everyday lives, if someone texts you a ridiculous accusation like, you owe me $1 million for breathing my air, you'd probably just ignore it, right?
Yeah, you'd roll your eyes and go about your day.
Exactly. But in this administrative framework, ignoring a properly formatted notice is the most legally fatal mistake an entity can make.
It is. The sources explicitly cite the Uniform Commercial Code here, specifically UCC Section 2201, which deals with formal written confirmations.
UCC 2201.
Right. The internal logic of the documents dictates that if a party receives a formal, sworn commercial notice, and they do not rebut it point by point in writing within a specific time frame,
Which is usually, what, like a couple of weeks?
often 10 to 30 days.
Yeah.
If they don't rebut it, the contents of that notice legally become an admitted fact in commerce.
Wait, so if I send a letter to Megacorp Bank stating, you do not hold the original wedding note, therefore the debt is invalid, and the bank simply ignores it because, their mailroom only processes standard payment coupons.
Their silence legally translates to them saying, yes, we agree with you.
That is wild. According to the mechanics outlined in these documents, they are just agreeing with me by not fighting back.
Yes. The process is designed to be entirely self-executing.
Let's pause on that term, self-executing, because that feels important.
It is. A traditional lawsuit requires a third party, a judge or a jury, and they have to weigh conflicting evidence, hear arguments, and render a verdict.
It's subjective.
Right, it is subjective and relies on an external authority. But this administrative process is presented as an objective mathematical formula.
Just input and output.
Exactly. It relies purely on notices, timelines, and defaults. You set the trap, you start the timer, and if the timer runs out without a written rebuttal, the mechanism executes itself.
The default becomes the truth.
The controversy is settled by their inaction.
It's a brilliant exploitation of corporate bureaucracy, honestly. Think about it like missing your window to contest a parking ticket.
That's a perfect analogy.
If you get a ticket and you know the meter was broken, you have a specific window of time to mail in your dispute.
Right.
If you wait 6 months until the city has already put a boot on your car and then you try to tell them the meter was broken, they do not care.
They don't care at all. You had a window to dispute the facts, you slept on your rights, and now the law locks you out of the conversation.
By failing to speak up, you legally acquiesced to the debt.
That is the exact mechanism, just scaled up and applied offensively against the financial institution. The entire system is a commercial snare, designed specifically to capture the opponent's inaction.
But, the obvious friction point for me is the fragility of that snare. There has to be a vulnerability in the strategy. What happens if the megabank actually reads the letter and responds?
The sources acknowledge this as the primary failure point.
Okay, so they know it's a risk.
Definitely. If the bank receives the letter and a competent clerk or attorney actually reads it and officially responds within the time frame.
Or if they miraculously produce the wedding note.
Exactly. If they do that, the formation of acquiescence is broken.
The trap fails to spring.
The entire self-executing process halts immediately. The logic requires their silence to create the consent. If they break the silence with a proper rebuttal, you do not get the default and you cannot proceed to the later stages of the process.
You are forced into a traditional legal battle.
Which is exactly what you were trying to avoid.
Which really highlights why this whole procedure relies on the bank acting like a slow, dumb, automated machine. It preys on their tendency to ignore things that don't fit neatly into their standard digital forms.
It is an asymmetrical strategy. The living man is agile and intentional. The corporation is massive, rigid, and slow.
Okay, so we've established the players. We have the living man with substance versus the corporate fiction with form. We've established the rules of engagement, the triad, and the lethal nature of acquiescence.
Now we initiate the procedure.
Let's officially initiate this procedure. Let's walk through the opening moves.
This brings us to stage 1 of the administrative due process, which the sources term the initial notice or the period of commercial grace.
Commercial grace. It almost sounds like a religious dispensation, like you are offering them a chance at salvation before you bring down the hammer.
In a procedural sense, you are doing exactly that. The purpose of stage 1 is to establish the facts on the record and clearly define the terms of the relationship.
You're setting the baseline.
Yes. The living man is providing the corporate entity with a fair, documented opportunity to perform according to the law. You are showing your willingness to settle the matter honorably.
But what is the actual instrument used here? Like, if I'm doing this, what piece of paper am I actually putting in the mail?
You are sending a document, typically titled a Notice of Statutory Violation in Demand for Accounting.
Notice of statutory violation.
Or sometimes it's called a qualified written request.
And the delivery method is crucial here, right? I mean, you don't just drop this in a blue mailbox on the corner.
Oh, absolutely not. Every single step relies on verifiable proof. You use certified mail, usually with a return receipt requested.
It's a little green card.
Exactly. The logic, relying on UCC Section 1202, is that this notice becomes legally effective the exact moment it is delivered to their place of business and signed for by their mailroom,
So the clock starts ticking upon delivery.
regardless of whether an executive ever actually reads it.
Wow. And what does the letter actually say?
The content is highly structured and very direct. First, you state the specific violation.
Like what?
For example, you allege that they are attempting to collect on an unverified debt or that they are operating without a valid wet ink contract.
Okay, step 1 is the accusation.
Second, you demand the substance. You explicitly demand they produce the original wet ink note to prove their standing.
Send me the blue ink.
Right. Finally, you give them a specific rigid response window, usually 10, 14, or 30 days.
You demand the physical keys, not the digital photograph. So I send the certified letter. I get the green card back saying they received it. The timer ticks down. Day 30 arrives. Crickets.
Silence.
Megacorp Bank's automated mailroom didn't have a barcode to scan on my demand for accounting, so they tossed it in a filing cabinet and just ignored it. Do I win right then and there? Like, can I foreclose on them on day 31?
Not yet.
Dang it.
The administrative process requires extreme patience and a meticulous building of the record. This introduces stage 2.
Stage 2, what's that?
The sources call it the notice of fault and opportunity to cure.
Opportunity to cure. Wait, I am giving them another chance.
Yes, you are.
But hold on. I'm dealing with a mega bank that uses predatory tactics. Their mailroom threw my letter in the trash. If my whole strategy relies on a paper trail, hasn't the bank just broken my process by ignoring me? Why am I giving them a second chance if they already blew the deadline?
That is exactly what you want them to do.
Wow.
Because administrative law and the internal logic of this UCC process requires you to demonstrate that you exhausted every possible administrative remedy.
Oh.
You must prove on the record that you gave them every conceivable chance to do the right thing. You don't just jump to a penalty. You have to set a legal safety net. That safety net is the notice of fault.
Ah, so it's not about being nice.
Not at all.
It's about making the record bulletproof. If I end up showing this to a judge later, I need to look like the most reasonable person on the planet.
Precisely the point.
Yeah.
You are officially noticing them that they failed to respond to stage 1. You are legally documenting their negligence.
Got it.
You are essentially writing to them and saying, I notice you missed the deadline. Perhaps it was an oversight. I am granting you one final opportunity to cure this fault.
How generous of me.
Very. And then you give them a much shorter window, usually just 3 to 10 days, to provide the wedding document.
Now, there is a very specific concept introduced in the texts around this stage regarding the trust. And this is a bit dense, so I want to break it down. The sources say the living man uses a trust to sever liability. How does a trust fit into this equation?
This is a crucial element of the underlying theory. In this worldview, your name written in all caps.
Like on my driver's license.
Exactly.
Right.
Like you see on your driver's license, your birth certificate, or your bank statements. The theory is that that name is not actually you.
It's not me.
It is considered a corporate fiction, a straw man, or a public trust created by the government. The theory posits that flesh and blood people have been tricked into acting as the surety or the guarantor for this corporate fiction's debts.
So when Megacorp Bank sends a bill to John Doe in all caps, They aren't billing the breathing human.
No, they are billing the corporate fiction.
But they are hoping the breathing human will just step up and pay it out of habit.
That is the core assertion, yes. Therefore, the living man utilizes a private common law trust to hold his physical assets, his substance.
Okay, so I separate myself from the all caps name.
Right. When you send these notices, you are often acting as the executor of your private trust, interacting with their corporate fiction.
And the texts have a very evocative visualization for what happens in stage 2 regarding this liability. They call it the hook.
The visual metaphors in these documents are highly intentional. They use imagery to simplify complex commercial severances.
And the text describes an image of a literal sharp fishhook. And the hook is labeled note, as in the promissory note, the alleged debt that has dug into you.
Yes.
And this dangerous hook is in the process of being cut away from the fishing line by a pair of scissors. And the scissors are labeled trust. Let's analyze that mechanism. What is actually happening there legally?
The metaphor represents the severance of personal liability from the physical asset. Because the bank failed to produce the wedding note.
Because they ignored stage 1.
Right. Because they failed to prove the physical substance of the original contract, they cannot prove that the living man ever legally obligated his private trust to pay the corporate fiction's debt.
The bank can't prove I'm on the hook.
So the trust legally cuts the line.
Wow. By giving them that second chance and having them ignore it again, you solidify the fact that the hook is empty.
Yes. Stage 2 marks a major transition. We are moving from giving them a chance to play nice into actively building a weapon.
The bank's failure to cure the fault within those final 3 days marks their first official dishonor.
Yes. They have formally dishonored your commercial attempt to settle the matter.
And that dishonor is the raw material you need to build the next stage.
It is the absolute foundation of what comes next.
So stage 1 was the polite, formal request. Stage 2 was the final documented warning. They've ignored both. Their mailroom has failed them twice. Now we enter the territory where things get incredibly serious. We move to stage 3.
Stage 3, the checkmate.
The check.
Stage 3 is the pivot point of the entire strategy. Everything before this was set up, everything after this is enforcement. This is the issuance of the notice of default and certificate of non-performance.
Notice of default. And this is where that concept of acquiescence, silence is consent, finally bears its teeth.
The purpose of stage 3 is, in the precise terminology of the process, to close the mouth of the respondent and finalize the administrative record.
Close their mouth. Meaning they had 2 distinct, documented chances to speak, they chose not to, and now they are legally gagged.
You issue this notice declaring the respondent in permanent default.
Permanent default, that sounds final.
It is a fatal status within this framework. Because silence is consent, your unrebutted affidavit, your sworn, notarized statement detailing the timeline and their failure to produce the evidence, now stands as what administrative law refers to as the truth in commerce.
Truth in commerce. I want to linger on that phrase for a second.
It's a powerful phrase.
It really is. It implies that objective reality doesn't even matter anymore. Like, it doesn't matter if, in physical reality, I did actually sign a mortgage document 5 years ago. It doesn't matter if I walked out of that bank with a check for $500,000. What matters is the paper trail we just created over the last 40 days.
Within the strict confines of administrative procedure, that is the assertion. The truth is no longer what happened historically.
It's what's on paper.
The truth is what is established on the uncontested administrative record right now. The respondent, by permanently defaulting, has legally waived their right to introduce new evidence or dispute the facts you have established. The window for debate has slammed shut.
To me, the most fascinating part of stage 3 is how you actually execute it. It's the role of the witness. We talked about the I, thou, he triad earlier.
Yes, the he.
The independent third party. I know I don't just print this notice of default on my inkjet printer and drop it in the mail myself. How does the he practically work here?
The sources are exceptionally specific about the mechanics of this step. You bring in a notary public.
A notary, like the person who stamps documents at the local shipping store or bank branch.
Yes, but it requires a deep understanding of what a notary actually is historically. We tend to think of notaries today as just people who check your ID and watch you sign a car title.
Yeah, that's what I think of.
But historically, and in the context of international commercial law, a notary public is a powerful, independent officer of the state. They hold a state commission. In this process, the notary is elevated to a crucial commercial role. The notary acts as the objective state-sanctioned witness.
Okay, so how does the interaction with the notary actually go? Do I just walk in and say, hey, the bank ignored me?
Not quite. The living man presents the entire history of the correspondence to the notary. You bring the Stage 1 notice, the certified mail receipts, the Stage 2 notice, the second set of receipts, and an affidavit swearing you received no response.
You bring the whole file.
Exactly. The notary's job is to verify the timeline. They verify that the notices were sent, the legal time elapsed, and no rebuttal was received. Once verified, the notary themselves issues and notarizes the document, creating a formal notarial protest or a certificate of dishonor.
Oh, wow. So it's not just me saying the bank defaulted.
Right.
A commissioned agent of the state government is issuing a formalized certificate stating that the bank dishonored the commercial process.
It adds a layer of absolute objective authority to the record. Courts of record are generally obligated to accept the facts contained in a notarial protest as true unless explicitly proven otherwise.
And since the bank is in default, they can't prove otherwise.
Exactly.
The psychological genius of this step is just wild. You are completely bypassing the adversarial court system. You aren't hiring a lawyer, filing a lawsuit, paying massive filing fees, and hoping a judge in a black robe agrees with your interpretation of case law.
You're avoiding all of that.
You are using the mundane, everyday administrative power of a notary public to legally certify that the giant corporation essentially surrendered by not showing up to the fight.
Surrendered by silence.
The debate is officially closed. The scoreboard is locked.
It is a remarkable inversion of standard legal procedure. It turns the bank's massive size and reliance on automated forms into its greatest weakness. But, this naturally raises an incredibly important question about practical application.
I think I know what you're going to ask.
Having a notarized piece of paper that says you won a philosophical argument is intellectually satisfying.
Sure, it feels great.
It might feel like a massive victory over the system, but a piece of paper doesn't stop an eviction. It doesn't put money in your account. How do you turn this abstract truth in commerce into actual, tangible financial power?
Right. Megacorp Bank does not care about my notarized certificate if their computer system still says I owe them money and they are preparing to auction off my house.
They don't care at all.
Which brings us to the offensive maneuver. We have to make it hurt in the real world. We enter Stage 4.
Stage 4. Weaponizing the record.
Weaponizing the record. This stage is known in the texts as the perfection of the lien, or creating the security interest.
So we've won the argument on paper. We closed their mouth. Now we have to convert that silence into leverage.
The goal here is to convert the administrative default, the certificate of dishonor, into a literal, publicly recorded financial encumbrance against the corporate entity's property or their credit profile.
How exactly do the sources say you achieve that? What is the actual mechanism?
Well, you use the established default as the foundation to issue a statement of lien, or, more commonly, a UCC1 financing statement.
A UCC1. I've heard that term in business contexts. It's a standard commercial form, isn't it?
It is the bedrock form of commercial lending. Whenever a business takes out a loan to buy heavy machinery, the lender files a UCC1 financing statement with the Secretary of State.
It's public declaration.
Exactly. It is a public declaration that the lender has a financial claim, a security interest on that machinery. If the business goes under, the lender gets the machinery first. But in this administrative process, the living man is taking this standard commercial tool and using it offensively against the bank.
Under UCC Article 9, which governs secured transactions, by filing this document based on the uncontested default, you are radically elevating your legal status.
I am no longer a debtor begging for relief.
No, you are now a secured creditor.
According to the mechanical logic of the process, yes, you hold a perfected security interest against the bank.
Wait, hold on. I need to play devil's advocate here because I know a bit about commercial law.
Do it.
Article 9 of the UCC usually requires a signed security agreement from the debtor before you can just go and file a lien against them. I can't just go file a UCC1 against my neighbor because he annoyed me.
Right, you can't just invent a lien.
So how do the sources justify bypassing that requirement? Where is the signed agreement from the bank saying I can lien them?
That is the exact friction point traditional lawyers always raise. The sources address this by looping back to acquiescence.
Silence is consent again.
Yes. The internal logic dictates that your Stage 1 and Stage 2 notices explicitly stated that failure to respond would result in their agreement to a specific set of terms, including the creation of a security interest.
Oh, okay.
When they defaulted in stage 3, that unrebutted default became the legally binding security agreement. Their silence was the signature.
Wow. Okay, so the silence grants the permission to file the lien. But how do I calculate the amount? How do I determine what Megacorp Bank owes me? Do I just make up a number like, you've ignored my certified mail, so you owe me $10 billion?
It cannot be arbitrary or it falls apart under scrutiny. The texts indicate that you calculate fines or damages based on specific legal violations that you alleged in your initial notices, violations which they subsequently failed to rebut.
What kind of violations are we talking about?
The documents frequently point to TILA violations, the Truth in Lending Act.
How does TILA fit into this?
This connects back to the substance versus form philosophy. A core argument in these theories is related to fractional reserve banking.
Right, the way banks create money.
Exactly. They argue that when you get a mortgage, the bank doesn't actually lend you physical substance. They don't lend you actual gold or labor. They simply create credit out of thin air by typing digits into a computer.
Using your signature as the collateral.
Using your physical signature, your substance as the collateral to create the funds. The theory claims this is a failure to disclose the true nature of the loan, which is a massive TILA violation.
Oh, I see. Because they never disclosed that you were actually the one creating the value with your signature, they committed fraud.
Exactly. Other damages can be calculated based on the unauthorized use of the strawman name, or even charging the bank for improvements made by the trust to the physical property over the years, like fixing the roof or paying property taxes.
So you build a ledger of damages based on these theories, and because the bank is in permanent default, they are legally barred from arguing with your math.
You calculate the sum, you put it on the UCC1 form, and you record this lien publicly. You file it with the county recorder for real estate and with the Secretary of State for commercial assets.
And this brings up a mechanical question. Why would a county clerk accept this wild document?
This is a crucial vulnerability in the public recording system. County clerks and Secretary of State offices generally operate in a ministerial capacity.
Meaning what?
Meaning they are not investigators and they are not judges. Their job is simply to intake documents, ensure the form is filled out correctly, collect the filing fee, and stamp it into the public record.
They don't verify the claim.
If the UCC1 is formatted properly and you pay the $25 fee, the clerk must record it. They do not have the authority to determine if the underlying claim is valid. The public record simply accepts the filing.
There is a visualization from the text here that I think perfectly illustrates the devastating real-world impact of this stage. They call it the cloud on title.
It is an incredibly apt legal metaphor.
The text describes a visual of a small, neat house icon. And hovering directly over it, casting a shadow, is a dark, heavy cloud labeled Statement of a Lien. What does that dark cloud actually do to the bank's operations?
It paralyzes the asset entirely. In real estate and commercial law, a clear title is absolutely required to transfer property.
You can't sell a house with a lien on it.
Right. If there is a perfected security interest, a massive financial lien recorded against the property in the county records, the title is considered clouded. The bank cannot legally clear the title to sell the property to someone else.
And they can't foreclose either.
More importantly, they cannot easily proceed with a traditional foreclosure because this new, publicly recorded financial roadblock is sitting right in their way.
By filing a standard commercial form based entirely on their failure to answer a sequence of letters, you have essentially thrown a massive steel wrench into the gears of their automated machine.
The abstract philosophical default is now a concrete, legally binding roadblock. They want to sell the house at auction. They have to deal with the cloud first.
They must legally satisfy the perfected interest of the secured creditor, which, according to the public record, is now you, before they can move forward with any action on that property.
Okay, let's take a deep breath and summarize the architecture we've built so far.
Yeah.
Because this is an intense ride.
It's a lot to take in.
You establish the foundational rules. Physical substance beats corporate form. You utilize the ITHO triad and sent your notices.
The bank, operating like a blind automated bureaucracy, stayed silent.
You use a notary public to mathematically certify their default and close their mouth.
And then you took that certified default and used it to file a public lien, locking down their physical asset and legally transforming yourself into a secured creditor.
So what does this all mean for the end game? How does the living man actually collect or enforce this new power?
That brings us to the fifth and final stage of the procedure, enforcement and execution.
Stage 5, reaping the rewards.
The primary instrument used in this final stage is typically called a notice of intent to levy or a distress for performance. You are officially announcing your intention to collect on the massive debt that was established and publicly secured in the previous 4 stages.
But surely this is the moment the bank wakes up, right? This is when their army of lawyers gets an alert that someone filed a massive lien against their asset.
You would think so.
If they try to fight back now, if they file an injunction and say, wait a minute, this is totally ridiculous, this person owes us money, we are foreclosing, what happens?
The sources claim that any late-stage defense by the bank is blocked by a foundational legal principle called equitable estoppel.
Equitable estoppel. Let's define that clearly, because it sounds like the final nail in the coffin. Think of our parking ticket metaphor again.
It is the exact same principle. To be estopped simply means to be legally prevented or stopped from taking a certain action.
Okay.
Equity, in a legal sense, demands fundamental fairness. The doctrine of equitable estoppel states that it is fundamentally unfair for a party to remain silent when they had a clear duty and opportunity to speak and then suddenly speak up only when it benefits them.
So they can't speak up now just to avoid the consequences of their previous silence.
They cannot rewrite history. They cannot suddenly say the rules of the game don't apply when they already forfeited the match 3 stages ago.
Precisely. Because the bank defaulted earlier, because they were given multiple documented opportunities to object during Stage 1 and Stage 2 and failed to do so, they are legally stopped from asserting any claims, defending themselves, or changing their position now.
They are locked into the reality created by their own default.
Okay, so the bank's lawyers are theoretically gagged by equitable estoppel. What aggressive actions can the living man, the newly minted secured creditor, actually take to enforce the lien?
The sources outline 3 primary avenues for enforcement. The first is a concept called set-off.
How does a set-off function in this context?
Think of it as advanced accounting judo. Let's say the bank's computer system still claims you owe them $2,000 a month for a mortgage, but through this exhaustive administrative process, you have established a $2 million lien against the bank for TILA violations and fraud. Set-off means you simply use the debt the bank now legally owes you to offset or cancel out the alleged monthly payments they are demanding from you.
You pay their bill with the debt they owe you. Like, I see your invoice for $2,000, and I will just deduct that from the $2 million you owe my trust from the perfected lien. Keep the change.
Exactly. It nullifies their demands without the exchange of any actual currency. The second avenue for enforcement is much more aggressive, and it's called non-judicial foreclosure.
Wait, I can foreclose on the bank. I can take the bank's property.
Under certain UCC provisions, if a secured creditor's lien is determined to be superior, meaning it was recorded properly and has priority over other claims and the debtor is in default, the creditor can move to take physical possession of the collateral without needing a court order.
No court order needed.
Right. Because the bank is stopped from defending themselves, there is theoretically no legal entity capable of stopping the foreclosure process. The living man repossesses the asset.
That is staggering. It is the ultimate inversion of the dynamic. And what is the third avenue? What if the bank tries to use force, or you need to clear the title completely to sell the house? What if you do want to involve a court?
The third option is filing a formal commercial claim. This is where you take the entire perfected administrative record, the certified notices, the notary certificate of dishonor, the UCC-1 filing, the evidence of equitable estoppel, and you bring it to a court of record.
But wait, earlier we said the whole genius of this system was to avoid judges and courts. Why walk into the lion's den now?
Because you aren't going to court to ask for a trial. You are going to court for execution. The sources emphasize heavily the concept of self-authenticating evidence.
Self-authenticating, meaning the evidence proves itself on its face. It requires no external validation.
Correct. When the living man brings this perfected, notarized package to a court, the theory argues that the judge does not need to verify the facts, hold evidentiary hearings, or listen to oral arguments from both sides.
Because of equitable estoppel.
Because of equitable estoppel, the bank is legally barred from arguing. Therefore, there is no controversy for the judge to adjudicate. The court must automatically accept the administrative record as undeniable proof. The victory is self-evident on the paperwork.
So essentially, the court isn't there to referee a debate between two parties. They're just there to read the scoreboard that the living man has already finalized in private commerce and then hand over the trophy.
The judge acts in a ministerial capacity, just like the county clerk.
That is exactly how the sources describe the optimal endgame of the procedure. The court is merely the enforcement arm of the private commercial reality you built.
There's one final visual metaphor from the text that I think ties this entire five-stage machine together perfectly. It's an image of interlocking gears.
Oh, yes, the concept of compelled performance.
The visual is a set of heavy mechanical gears. One gear is labeled acceptance of payment. The other is labeled administrative estoppel.
Right. And the text explains that if the bank accepted your mortgage payments or your credit card payments for 12 months before you started this administrative process, they are mechanically geared into accepting your standing.
By taking your money month after month, they formally recognized you as a valid commercial entity.
This triggers administrative estoppel, preventing them from suddenly claiming later on that you don't have the legal authority to issue these notices or file these liens. The gears lock them into the process.
It creates an inescapable mechanical logic. Every single action or inaction taken by the corporate entity is used to tighten the snare around them.
It is honestly breathtaking in its audacity. Let's just do a rapid recap of the transformation we've just unpacked over the last hour.
Yeah, a quick summary is definitely needed.
We started with a scenario where an isolated individual felt entirely crushed and outgunned by a trillion-dollar corporate fiction. But by utilizing the Uniform Commercial Code, the bank's very own rulebook for commerce, and adhering to strict, unforgiving timelines, the living man systematically moves from playing defense as a terrified debtor to playing offense as a secured, enforcing creditor.
You demand physical substance.
You set the trap to capture their silence.
Use a notary to certify their default.
You weaponize that default by filing a public lien to lock down their asset.
And finally, you enforce the debt using their own inability to argue back due to equitable estoppel.
It is a complete systemic inversion of the traditional paradigm of debt, law, and power.
And regardless of how a judge might rule on this in a real courtroom, just exploring the internal logic of this deep dive really makes you, the listener, look at the mundane, everyday details of your life completely differently.
It really does. Think about how much of our daily existence relies purely on unexamined forms. Think about the massive click-wrap agreements we blindly scroll past and hit accept on.
Or the generic automated notices we throw in the recycling bin without reading.
Think about the black and white photocopies we accept as absolute truth. This deep dive challenges you to ask, where is the tangible substance in my life?
What happens if I stop accepting the form? What happens if I demand the physical reality?
And that line of questioning leads us to a fascinating and perhaps slightly terrifying philosophical dilemma, particularly as we look toward the immediate future.
Give it to me. What's the final thought we are leaving the listener with?
Think about the foundation we laid at the very beginning. The entire weight of this massive administrative process, the very ability to legally distinguish the sovereign living man from the dead corporate fiction, hinges entirely on the physical reality of a wet ink signature.
Blue ink pressed onto physical paper by a human hand.
But we are moving rapidly, inevitably, into an entirely digital world. Smart contracts on the blockchain, cryptographic keys, biometric facial scans, and centralized digital identities are replacing physical paper every single day.
The physical document is dying. If physical blue ink disappears entirely, if it go away completely, how will the living man prove his private capacity in the future? If absolutely everything we interact with becomes a digital form, how do we ever legally prove our human substance?
Oh man, if the physical ink dries up, how do we prove to the machine that we aren't just fictions ourselves? That's a heavy, profound question to leave you with. Thank you so much for joining us on this deep dive into the architecture and mechanics of administrative due process. It has been an absolute mind-bender of a discussion. Keep questioning the form, always look for the substance, and we will catch you on the next deep dive.